And Nicolene says, hi, what about landlords who do not include the part about giving 30 days notice when you want to cancel a lease agreement early? If it just says you leave without staying for the full term you signed for, then you lose your deposit. So I think there's a bit to this question. I think there's two sides to it, from a landlord's perspective as well as from an individual who may be leasing a property. I think we can quickly start with Bruno in terms of assisting Nicolene here.
Sure. So it's actually a really good question, and the reason you find that scenarios like this actually transpire is the fact that lease agreements are drafted by different individuals, and sometimes they're amended by, unfortunately, the landlord that doesn't quite understand the basic laws that apply to leases. So they try and draft it to favor themselves, thinking that it's enforceable in, even if not drafted correctly. So when it came to things like evictions and spoliations, for example, there used to be plenty of lease agreements in the past that made provision for allowing for a landlord to lock a door or to prevent a certain service from being rendered, not realizing that you're not actually allowed to do that. The reason why you're not allowed to do that is although in South Africa we have the freedom to contract, there's certain fundamental rights that are promoted in the Constitution and thereafter enabled or entrenched in enabling legislation. So there's actual legislation in place that looks at the importance of the Constitution and sets down in detail how these rights are to be enforced. So for example, the right to housing in terms of the Constitution can very easily be said to be protected in the Rental Housing Act, can easily be said to be protected in the Consumer Protection Act that deals with consumer rights and tenant rights and things like that. So long story short, if a lease agreement doesn't contain the 30-day cancellation period that a tenant can give, one needs to ask the question. First thing is, a lot of lease agreements are fixed term agreements. So not every lease agreement has to have a 30-day clause technically, because it's not a month-to-month, it's a fixed term lease agreement. But in terms of the Consumer Protection Act, a tenant is allowed to terminate a lease agreement earlier than what they would be entitled to. So if it's a year lease agreement, the tenant can still terminate it after 6 months or whatever the case is, in terms of Section 14 of the Consumer Protection Act. But in terms of that section, it's not just the tenant can do whatever he wants, the landlord has no recourse. The landlord is entitled to charge a reasonable penalty for doing it. So the tenant doesn't walk away scot-free. He can just get away from sitting on the property for too long, and to his prejudice, but he doesn't get away scot-free. He still needs to make up to the landlord possible losses, and these losses can be calculated as a reasonable penalty fee and could include, for example, the amount of time it would take for a landlord to find a suitable replacement tenant. You need to put it up on the market, you need to maybe fix it up, paint it. So a lot of places have a 2-month cancellation penalty or a 3-month cancellation penalty. So to say that simply the deposit is a cancellation penalty could fly, because it's actually normally just 1 month. So one could potentially try and argue that it's the value of the deposit that works as a cancellation penalty. So yeah, there's nothing necessarily wrong with it. I have seen cancellation penalties that are 1 month, and the tenant still has recourse, and they can question it and argue that it's not reasonable, and that's an argument for a different day. So to answer your question, does the lease agreement have to contain the clause? No, it applies by law. So a tenant has that right, irrespective of whether the lease has it or not. Is it fair for a deposit to be the cancellation penalty? To a certain degree, the value of the deposit, if it's 1 month, I've seen that as many cancellation penalties. So I would argue that even though the Rental Housing Act has a certain way on how the deposit has to be repaid, the fact that you're connecting the cancellation fee to the value of the deposit doesn't seem to be all that bad to me. I don't know, Nick, if you agree with that.
No, 100%. As you know, the reasonable cancellation penalty is just a call to make sure that there's some reasonability to it. And I think, you know, in circumstances where you've got a deposit, which is generally a month, maybe two, you know, depending on the particular lease agreement, really, I think that falls under the definition of reasonable.
Sure.
You know, the legislation is really trying to prevent landlords from claiming, you know, a full 12-month period while they have another tenant in and have been able to mitigate their damages in the circumstance.
Absolutely. Yeah, absolutely.
The one interesting thing I just wanted to mention was the way that I had read the question was whether it was coming from a landlord's perspective. So I think it's important to note that, you know, Section 14, Consumer Protection Act, obviously is protecting the rights of the consumer and allows them to cancel in the circumstances. But that same right is not afforded if you're sitting in the landlord's position. All right. The landlord is going to have to rely on a breach of the contract and then obviously give notice for, you know, for remedying of the breach in accordance with that same section. So they can't cancel their lease agreement just at any point in terms of that particular section. If that question was framed from a landlord's perspective, I'm not
sure. Yeah, that makes sense.
So thanks, guys. Really appreciate that. And I'm sure Nicolene does as well.